Thanks so much. My name is Grant Wells. I'm Director of Innovation and Development for Stanford MCHRI. We are so excited for today's seminar on data use decoded, navigating data use agreements at Stanford. I think, as we all know, this is a hot topic, a very uh, exciting and interesting topic from all of our lived experiences with these agreements. We are very blessed today to have two of our colleagues from the Office of Sponsored Research, Allison Ramos and Sue Kim. Thank you so much for being here. Hopefully, we'll have a lot of time for questions. So please put those in the chat and we'll kind of answer them as they come up. Next slide, please. Just first of all, want to thank our education committee who really help us put these seminars on. If you are interested in joining the committee, please let us know as well. Just want to put a special feature for our next session, which is coming up on February 23rd, noon to 1. This is featuring our SURF grantees. If you've ever wanted to learn more about how to participate in community engaged research, or if that's an area where you have a project that may apply, I think this is a great opportunity where you can see firsthand the case studies of those that are recipients of our grant funding for that, as well as how they're partnering with those community research organizations and community-facing organizations to accomplish these research projects. And just another seminar put on your network. Another really, I think, great resource-driven topic is what is the Trial Innovation Network? Really interesting topic. Maya Berdichevsky and Laura Simons will present as kind of an overview from Maya, as a direct experience that Laura will provide as well. And just a host of other ones. Put these on your agenda. Come back, check our announcements. Got some really great topics that are coming up. But without further ado, really excited to kind of dive in to today's session. And I will hand it over to Allison and Sue. Thank you.
Hi, everybody. I'm going to get set up here, share my screen. Can everyone see these slides?
Yep, they look great.
So, perfect. So, as Grant noted, this is Data Use Decoded, Navigating Data Use Agreements at Stanford University. I'm Allison Ramos. I'm a Managing Senior Contracting Grant Officer here in the Office of Research Administration on the pre-award team. I support most divisions of pediatrics, so I've probably worked with a number of you in this call today. So I'm happy to be here and introduce my co-presenter, Sue Kim. Go ahead.
Good afternoon, everyone. My name is Sue Kim. As Allison mentioned, I'm on the RRA team. I'm a senior officer and I handle a variety of RRAs, mainly data use agreements. Thank you to MCHRI for inviting us to speak on this topic. It's a pleasure to be here.
So here's our agenda for the day. We're going to go over several definitions throughout and discuss when our DOA is needed, the submission process for RRAs, which are research-related agreements, what we look at as institutional official or contracting grant officer reviews, why we care about certain things, provide some tips and best practices, and then go over a couple case studies to discuss at the end.
So before we dive into the main topic of DUAs, I'd like to briefly touch on what an RRA is. It's an acronym that's used often in this presentation, but also in SARA and by our office as well. A research-related agreement is a contract between Stanford and one or more parties for research activities that are not externally funded by a sponsor. This includes DUAs, but it also includes some common ones like MTAs, NDAs, collaboration agreements, non-sponsored subawards, consortium agreements, membership agreements, and etc.
And another thing I just wanted to touch on some of these acronyms that we use. SARA, what's a SPO versus an RRA? So what is SARA? SARA is Stanford's Electronic Research Administration Systems. It's our system of record that we use to track the lifestyle of a project from proposal to award. And now we've expanded this to track RRAs as well, those research related agreements. So you can log in and see where any of your SPO or RRA agreements are and track those negotiations as well and the status. So on my side, on the SPO side, we refer to SPO numbers. That is created so that we can track a funded research agreement from whether it's federal, nonprofit, for-profit. We get a SPO record and we'll refer to that. Your institutional official will refer to SPOs when talking about those funded research agreements. We should list that SPO number on all of your regulatory protocols so that the funding is appropriately linked to the right regulatory protocol that you have. And as Sue mentioned, RRA, research related agreement numbers, we use that RRA number to track those unfunded agreements that Sue just discussed on the prior slide. So you'll hear your institutional official refer to these acronyms when you contact us to check on status or want to know where your data use agreement is, perhaps in the process. And we want to link SPO and RRA numbers together in SARA so that we can track and see that if you have a sponsored agreement that has a separate data use agreement that's tied to that study already, if we link that together in SARA system of record, we can see that we don't need to add a separate data use agreement to your SPO, or we don't need to add data use agreement terms to your SPO agreement. So it's important that we link those two together so we understand the relationship between your research related agreements and your SPO agreements.
So as we dive into DUAs, I'd like to cover some basics first. What is a data use agreement? A data use agreement is a legally binding document that governs the sharing, access, and use of data between parties. Its purposes include who's permitted to use and receive the data, allowable uses, disclosures of that data by the recipient. It assigns appropriate responsibility to the researcher and recipient for using the data, and it outlines the responsibility of the parties with regard to applicable privacy regulations. So we've just noted that a DUA covers data, but what exactly is data as used in this context? Broadly, data is a collection of facts, figures, and other raw information that's been measured or recorded, and it can be qualitative or quantitative. Within the School of Medicine, we're often dealing with human subjects research, and more specifically, participant data that may have been collected under informed consents, retrospective data collected from the medical record, or secondary data that might have been generated from one of the two foregoing. So we have that broad definition of data, but we also want to take a moment to distinguish data versus research results, as these two terms are used by ORA. Data is typically raw information, as I mentioned. For example, in human subjects research, raw data is typically at the subject or participant level. On the other hand, research results are usually conclusions, findings, or outcomes that are generated by an investigator after analyzing or interpreting that data. Sometimes the results of an investigator's work might produce data, such as sequencing data, but if that sequencing data has not yet been analyzed or interpreted, that can also be considered raw data. A DUA might not be needed for research results unless there are specific regulatory considerations still attached to those results, or perhaps if the PI's expectations need to be addressed in an agreement. So continuing on the topic of whether a DUA is needed, our website has more detailed information about when a DUA is or isn't required. But at a high level, as shown here, a DUA is required when the data is outgoing, even if it's de-identified, if it's in one of these three categories. The first is if the data is in a category subject to the DOJ bulk data rule. The DOJ bulk data rule is a new US Department of Justice rule that prohibits US sensitive personal data or other government related data from being shared with certain covered persons. Because of this restriction, we're required to cover any such data under a DUA. The most common categories under the DOJ rule that would be applicable to the School of Medicine would be the ones that are bolded here: personal health data, human omic data, and human genomic data, and notably that these apply even if the data is de-identified. The second category when a DOA is required is when it's being sent to a foreign entity. And the third is if the data is proprietary, confidential, or there are other restrictions on transfer. We also wanted to note that even if the data is not under one of these three categories and a DOA is not required, we might suggest one when the PI wishes to formalize rules and responsibilities. For example, if the PI has specific publication or acknowledgement expectations or wants to identify and ensure that specific reporting or deliverable requirements are met. So as some of you may know, MCHRI distributed a survey in advance of this DUA presentation, and one of the questions from the survey, and also a question that I sometimes get from faculty, is why do I need a DUA if I already have an IRB protocol? And that protocol already addresses the sharing of data. So this slide is hopefully intended to clarify that. A DUA is a legal contract. It manages data-related risk. It governs data access, use, sharing, security, and retention. It protects institutions and data owners. It's enforced through contract law, and it applies inside and outside human subjects research. On the other hand, an IRB is a regulatory requirement. It manages human subjects risk. It governs research design and conduct. It protects participants. It's enforced by regulation and compliance, and it applies only to human subjects research. So really the bottom line is that an IRB protocol is a federal regulatory requirement that evaluates whether the research ethically protects human subjects, whereas a DUA is a legal contract that defines the terms under which specific data may be accessed, used, and protected. So while both of these might address the use of research data and may touch on its respective functions, they're not the same and one doesn't replace the other. Another thing I wanted to note is that even when participants consent to data sharing, a DUA is still required because the consent addresses participant permission, whereas a DUA addresses institutional and legal authority over the data.
So other agreements that involve data, so on the sponsored project side, if the parties, we can cover, this is where we're hoping to simplify some of the data use agreement space and not have separate agreements each time. So when we might be able to cover data transfer under other agreement types is if the parties are carrying out a joint project. So if we're working with a collaborative group and we're receiving funding from them or we're sending funding to that other entity, we can try to incorporate those data use and sharing terms within that agreement where we're sharing funding. And if materials being exchanged, we can try, and data is also involved, we can do one agreement, an MTA/DUA. So there's one agreement that covers both the sharing of materials and the sharing and exchanging of the data within that one agreement. In addition, if you're paying a third party for a procurement service, that's another situation where we can incorporate data use and sharing terms in that agreement as well. As long as those agreements and collaborative projects are with the same parties in which we're sharing the data, we can incorporate that into the same agreement. And if you have any doubt or questions, you can always reach out to OSR intake or your institutional official to ask whether or not your current agreement that's being negotiated on the sponsored project side, or as a subaward, if that needs to involve data, you can reach out and ask if we can incorporate those terms into that agreement to avoid having to do a second data use agreement. And how do you initiate a data use agreement to be reviewed or drafted by our office? One, you can simply just send an email to OSR intake with a list of information so that we can get started. And Sue's going to go into details about what kind of information we're looking for to initiate a data use agreement. Our preference is for you to initiate this and submit an RRR, which is a research related request, and that's in SARA. And this will allow you to check what type of situation you have that you need an officer to draft your agreement for. So we can look and see, are you sharing data? Is it incoming? Is it outgoing? Are there materials involved? So there's a list of checkboxes and other information that you fill out on your own in SARA that will help us draft the right type of agreement. And you can initiate that in SARA there's a hyperlink here on how to submit a research-related agreement request, and a hyperlink here as well if you are modifying or amending an existing research-related agreement.
So whether you initiate the RRA request directly in SARA or whether you go through intake of the two options that Allison just mentioned, there's some information that will be helpful to have on hand as you prepare to submit in either case. The first is simply knowing who your external party or counterparty is. Next is an agreement template if one has been provided by the other party, a PI waiver if applicable, the research plan or statement of work, a list of data elements if possible. This might look like a data dictionary or a data collection sheet or the REDCap survey, a blank template of the REDCap survey. And lastly, any related agreements that would be helpful or relevant for the officer's review, as well as SPO numbers as listed here.
And here's the link to SARA. Most of you probably already have this, but if you don't, there it is. And when you log in, you'll either see one of these two options of My Projects or My Dashboard. And it's really simple to just click Start RRA Request. And it will look something like this, where you will check a box, all of which, whether they all apply or none of the above apply. If you do check none of the above, please note we will probably have a lot of questions as follow-up to understand, so that we understand what your goals are for the specific agreement that you want processed. But if you're doing data, you can simply check these and initiate start, and it will then prompt you to fill out the SARA record here and all of the different tabs along the side. So that's what that looks like in SARA. Oops, I clicked the wrong link. Sorry about that. And so there you'll click start. And once you've saved it and you log in to SARA again, if you need to save it and come back later, you'll click go open into SARA, and your first dashboard should show that there's an RRA pending in your queue. And you can simply click on that hyperlink to restart it and finish the entering in the information that you need to submit that request over, and it will be received by our intake team.
So what happens after the request is submitted? Either via directly by the investigator or research admin or received via email from the intake team, what happens? The intake team will then review for missing information. If it was received via email, the intake team will also set up the RRA request for the PI to review and approve. Another note on PIs approving is that if it was admin or staff that created the RRA request on behalf of the PI will ultimately need to approve that request in SARA before it's fully submitted. Whereas if the PI is the one who is creating and submitting the request, that approval is tied into the submission. Then after that, it's assigned by our intake team to an officer for review. So another question that came up in the MCHRI survey that we'd like to address is what the officer's review entails exactly and why it matters. So to start, we're reviewing the documents, the RRR that was submitted, the SOW, and the IRB protocol, other supporting documentation, all to ensure that the DUA actually addresses the data that's being transferred, the project that's being undertaken with it, so that the PI's research is not unintentionally restricted later. We're also reviewing the data scope or classification and the sensitivity of that data because different data types, be it de-identified, PHI, international, or other, requires different language in the agreement, often as required by law. We're also reviewing compliance requirements and corresponding approvals like IRB, privacy, hospital, and export control, as again, some of these are required by law or by policy, and reviewing and identifying these upfront can prevent delays or issues with the project down the road. We're also reviewing contract terms that directly affect the investigator. Things like publication, data retention, and reporting may affect the investigator's work downstream. The ability to publish and collaborate with others in the future may also be affected. So we're reviewing those terms to ensure that they align with the PI's expectations, but also so that the investigator is aware of things that they would be directly responsible for, like reporting breach to the other party or notifying the other party in specific timeframes related to various obligations. So as you can imagine, if an investigator has numerous DUAs for various data sets, each of those obligations represent things that then have to be tracked and accounted for the term of the agreement, which can often last for however long the term of the agreement is for. Lastly, we're involving our partner offices for reviews, like with Office of the General Counsel, the University Privacy Office, as DUAs often touch multiple areas that fall under our partner offices' purviews. These parallel reviews ensure that, again, issues are addressed up front and that issues don't arise down the road. The bottom line is that the officer's review is designed to align the agreement with the investigator's research to protect their ability to conduct and publish their work and to avoid preventable delays after data access begins. In many cases, this review is not an optional nice to have, and it may be required by law, institutional policy, or by the counterparty.
And I just wanted to note here as well that in addition to data use agreements, this applies to the sponsored project, just sponsored research agreements. We want to make sure that the SPO officers on our end are also doing this level of review to make sure that we're protecting the PI's ability to maintain ownership of their data, publish on their data, and conduct future research using their data and research results, even if it has nothing to do with a data use agreement, but is solely for a sponsored research or funded agreement. We are looking for similar things in our review.
An important follow-up discussion to what the officer reviews is what can the PI or department administrator do to help move this process along? First, we suggest discussing potential data transfer and data flow early on in a project at the outset if possible, particularly when there are multiple parties involved. It's possible, as Allison mentioned in an earlier slide, to address data transfer within a sponsored research agreement or a subaward or a collaboration agreement, but the window to do so is typically when those agreements are still being negotiated. Having said that, though, there's also a possibility that it's too early. If you don't know what data is being exchanged or you don't know who's going to be involved, it's certainly too early to initiate a DUA without having that information. The next is to, within the first bullet, is to also identify concrete deadlines early. It's helpful to the officer if there are immovable deadlines that they know upfront, to sort of manage the timeline and also to manage expectations, and perhaps even just to determine whether that is a feasible ask. The next is to be detailed. The more details and information that's provided to the officer at the outset will help the officer have a comprehensive understanding of what's needed for the agreement. We know that faculty have incredibly busy schedules, so providing details on the front end can hopefully reduce any back and forth that cuts into that time. The next is to ensure alignment between the various documents that are provided. The IRB protocol, the RRR, and the SOW should say the same things. For example, when there are discrepancies, for example, if the RRR says that PHI is being exchanged, but the protocol says that the data is going to be de-identified, those are things that the officer will need to investigate, usually leading to additional back and forth discussion. The next is concurrency. We suggest addressing any known compliance steps concurrently. If you already know that a DRA or hospital approval will be needed, we recommend proceeding to seek those approvals as soon as you know that they're needed, even before the DUA. And also, if those are initiated before the DUA, we also recommend letting the officer know either directly or in the RRR that those have been initiated to ensure that the officer is not asking redundant questions. And lastly, where possible, we suggest working with lower risk data like de-identified data. This is required under HIPAA and also under Stanford minimum privacy requirements, where the minimum amount of PHI needed for achieving the research purpose is exchanged. We also recommend working with frequent known collaborators, as that can help to expedite negotiations as well. One of the very common pain points with DUAs is why they take so long. You may have seen from the previous slide that there is a lot that goes into the officer's review, but there are also significant variations to every DUA scenario that might impact how long it takes to negotiate an agreement. For example, with external parties or the counterparty, if we're dealing with a nonprofit or government entity, we typically see more standard terms and less burdensome terms. This is often because Stanford, like other nonprofits, generally share public interest missions and operate under similar compliance regimes. Conversely, negotiating with industry or foreign partners typically is more complex because issues like IP and liability concerns take longer to negotiate. As you might imagine, the goal of a commercial entity is typically to protect their proprietary and commercial interests, which can often be at odds with the university's mission to disseminate knowledge, and all of that manifests during a contract negotiation. With foreign entities, there are other issues that give rise to longer negotiation as well, such as export control issues, different data privacy laws, and foreign influence risks. With data classification, de-identified or publicly available data will often have more standardized, straightforward terms, whereas high-risk data like PHI will often have extra safeguards and approvals that are required. The template used will also affect the timeline. standardized templates will benefit from a quicker turnaround. Some of you may have heard the term FDP DTUA. This is a standardized template that we try to use in the right circumstances, and it was created with the intention of creating a set of terms and conditions that would be easily used amongst research institutions. On the other hand, if we're dealing with a highly customized template from an external party, that will certainly take longer to review and likely raise the possibility of requiring negotiation with the other party. A straightforward one that affects timelines is response times from the involved individuals, such as PIs, our partner offices, and external parties. I'll also add in here that, of course, an officer's own response times can be impacted during busy seasons or as new officers onboard. Lastly, as I touched on in a previous slide, when we're met with issues that are defined by policy or regulation or requirements from the other party, these can take time to negotiate, mitigate, or escalate. For example, this can come up with publication restrictions, which surprisingly do come up fairly often, IP assignment issues, or foreign regulations like GDPR. So for the next few slides, we're going to shift gears a bit with some information that will be aimed at helping PIs and department administrators with the DUA process and some common issues that we see come up. The first is clarifying HIPAA definitions to ensure that the right terminology is being used in your IRB protocols, your RRA requests, and in general discussion with collaborators, because aligning these terms across study documents will ensure a speedier process and reduce that back and forth that I mentioned earlier. First, de-identify data is the removal of all 18 HIPAA identifiers from a dataset. If you're curious about the 18 identifiers, it's very easily found on Google, but it's all the common ones that you would think of, like names, addresses, medical record numbers, social security numbers, etc. But note that it also can't include any dates. It cannot include date of birth, date of admission, date of survey, date of death. Any date related to an individual would have to be removed. It also can't include any ages over 89 or any geographic subdivisions smaller than state. So it can't include county, it can't include city or zip code. The next is a limited data set. This excludes most of the identifiers that I just mentioned, but it can include dates, and it can include city and state or zip code, and it can include ages and years with months, days, or hours. Notably, a limited data set is still considered PHI that is subject to HIPAA. Lastly, the most straightforward one is identifiable PHI, which is a data set that would include one or more of the HIPAA identifiers. For this next slide, we'll talk a little bit about data risk assessments. Not all data sets, as you know, carry the same level of risk. They vary based on type, sensitivity, and applicable regulations. When the data is high risk, a data risk assessment may be needed. This is a joint University Privacy Office and Information Security Office review of the proposed data exchange. This is not handled by OSR, but when we know that a data exchange involves high-risk data, we may ask for a DRA approval. This review allows UPO and ISO to ensure compliance with Stanford's minimum privacy and security standards. Also, as mentioned earlier, we do recommend initiating a DRA early as soon as you suspect one might be needed. The DRA team has streamlined this process through their OneTrust system. And if you're not sure if one is needed, we typically recommend submitting one because if the data is recognized by OneTrust to be low risk, it'll provide an auto approval, which can be helpful to have on hand as you move through the DOA process. We discussed in an earlier slide the difference between an IRB protocol and a DUA, but what is the intersection between two of these, and what is the officer looking for? So this is in a scenario where the project does involve, or it may involve, human subjects research. The officer will be looking for alignment, as we talked about earlier. Specifically, we'll be looking to ensure that the collaborators accessing Stanford data are named, that the data classification, for example, PHI versus de-identified versus limited data set, are correct or aligned with what's in the RRA, and that any necessary consents, authorizations, or waivers are present. I should also note here that while our officers know what to look for, we ultimately defer to the IRB as the authority on IRB matters. So when in doubt, for example, if we're not sure whether protocol is needed or if a modification needs to be made, we'll likely defer to the IRB. For the former, if we're not sure whether protocol is needed at all, an HSR determination application can be submitted to the IRB. Or for the latter, if we're not sure if a modification needs to be made, we can inquire with IRB Education or the IRB panel manager. For the next topic, we'll look at the use of EPIC and STAR in relation to DUAs. So an important distinction is that the university and the hospital are separate legal entities. The university side oversees the research and the hospitals oversee clinical care. Because both EPIC and STAR involve the use of the hospital's clinical data, which is very common in School of Medicine projects, there are specific approvals that are needed from the hospitals. So in reviewing a DOA for outgoing data, the officer will be looking to see if the data was collected from either EPIC or STAR and whether appropriate approvals are in place. So to look a little more carefully at each of these, EPIC, as you all I'm sure know, is the EMR system used by the hospitals for clinical care. Clinicians likely are already using EPIC in the course of clinical care, but the research use requires separate approval, as mentioned. And the process to do this is by submitting a completed Exceed STAR capabilities form and a copy of the IRB approval to privacyofficer@stanfordhealthcare.org. For STAR, which is a repository that houses clinical data that's already approved for research use, a data privacy attestation is needed. The data privacy attestation, or DPA, should reflect the data elements being shared externally and should be attested to by the PI. And these approvals can be initiated prior to or in parallel with the DUA. And I think with that, I'll hand it back to Allison for some case studies to look at different scenarios.
Thanks, Sue. Now we're going to go into a couple case studies here. So this is a simple one agreement case study. We have a PI in Peds Gastro who's receiving an incoming subcontract from Boston Children's Hospital to fund a multi-center clinical trial that's funded by NIH. The study involves the sharing of incoming PHI level data from BCH. No materials will be exchanged. How do you get started, and can this be done with one agreement, and who will negotiate this? So hopefully and ideally we can get this all done within one sponsored research agreement or within the subcontract that Boston Children's Hospital issues to Stanford, and we'll have a SPO created for this. So if there's incoming PHI level data, we will ask all those questions that Sue went over to make sure we have the right information about the data that's being shared with Stanford to ensure we have the right protections in place. And we will include and incorporate the appropriate incoming PHI level data sharing terms within the subcontract that we get. So we have one agreement that issues the funding to Stanford, and we can incorporate that data use and sharing terms into that subcontract. You would send an email to OSR intake with the subcontract agreement, and we can set up a SPO. If it's already there, we'll set up an award transaction so to the SPO that's already been submitted as a proposal, and we will take it from there. You might want to loop in IRB, potentially ISO. If PHI were outgoing from Stanford, situation might change a little bit. And it's possible that we would get into a separate agreement with BCH. It would depend on where Stanford's outgoing PHI was, where it was going, if it was going to BCH or another third party. Another situation where in this scenario we might lead into having a separate data use agreement is if, let's say, this study had delayed onset of IRB, so the human subjects research work wasn't taking place and we weren't sharing data immediately. And so the PI needed to get access to their funding from NIH and from BCH, so to start spending. So if this was a 5-year study and year one didn't involve any data sharing, we might do the sponsored research agreement first, and we wouldn't address any data sharing. And then maybe in year two, we could either, with the amendment to the research agreement and subcontract with year two funds, we can incorporate data share terms there. Otherwise, we could do a separate DUA anytime as well. So it's really up to kind of the investigator in that situation if there was a delayed onset, whether to address the data sharing at a different time. But ideally, to simplify, we would want to have one agreement in this situation so that we avoid multiple agreements for one project to handle this situation. In case study 2 here, this might be multiple agreements. So we have a PEDS HEMONC PI receiving an incoming subcontract from University of Michigan to fund a multi-center clinical study funded by a foundation. This study involves the collection of blood and stool samples from patients, which will be sent directly to another party, Children's Hospital of Philadelphia. And there will also be PHI level data sent directly to CHOP, who's serving as a data coordinating site. So how is this different? We need multiple agreements at least. So we have the subcontract, the sponsored research agreement with Michigan and Stanford to address the funding coming to Stanford from the foundation via Michigan. But there would need to be a separate material transfer and data use agreement between Stanford and CHOP because CHOP is the data coordinating site. They're not party to the subcontract between Michigan and Stanford. So we would need to set up a separate RRA with CHOP because that's where we would address the materials we're sharing and sending to CHOP and the data that we're sending to CHOP. So at minimum, 2 agreements are needed. It's possible that another agreement would be needed depending on how CHOP and Michigan are operating this study, with Michigan being the sponsor and funder, or flow-through funder, and CHOP being the data coordinating center. So sending an email to OSR intake with all of the agreements that have been received, and we would set up that SPO and make sure that the subcontract with Michigan is set up under the SPO, and also make sure there's an RRA initiated so that we can address the data and material sharing with CHOP. And that would get assigned to 2 separate officers and institutional officials in our office. The SPO agreement would go to someone on my end in pre-award, and then the RRA for the MTA DUA would go to someone on Sue's team in the RRA side. And this is a scenario where we would want to make sure we link those RRA and SPO numbers when they're set up so that we understand that this is part of one study. These agreements are tied together so that we can track that internally and ensure that we have those noted as being related to one another. And then you would need to make sure that IRB and potentially maybe SRC is involved. I said that because it's HEMONC. If it's cancer related, you would need to submit to that group as well. And we would want to make sure in that IRB that all of the parties, Michigan, CHOP, the foundation, it's clearly listing out who's going to be the recipient of our patient's data, and that that SPO number is linked to the IRB approval or IRB protocol as well, so that we know we have approvals and are looking at the right protocol to align our contract terms with what's stated in the protocol and the ICF. We've talked a lot about sending things to OSR intake. I just wanted to make sure we give a shout out to Amanda Hart, Tara Buchanan, and Erin Kinney, who are members of our intake team. They're receiving all of those emails and assign the contracts to the right folks in our office. And they assign them to sponsored projects officers, SPO officers, or the research related agreement officers and the DUA officers. And we have links to our org chart and our department assignment list here as well, so you can tell which department you're in depends on which SPO or RRA or DUA officer you're assigned to normally in our group. And then we have our contact here, and then I was hoping we can open it up for questions and discussions in the last few minutes that we have.
Allison, Sue, can't thank you enough. What a tremendous session. We do have a ton of questions on the chat, and I'm going to try my best uh, to triage them, and then hopefully we can get through those and open it up further for questions as well. Um, so the first question is a DUA only needed for outgoing data? And I think you've clarified this, but with some of the case studies, but maybe just go over it one more time.
Sure. So generally speaking, when the data is incoming and the provider doesn't require a DUA for whatever reason, Stanford is not going to be the party that pushes one.
Perfect. And a complex question, more procedural, is how do I ensure my other agreements associated with grants and subawards and clinical trials include data sharing terms so separate DUAs are not necessary?
I think communication is key on that. You'll want to speak to the rights institutional official. So for clinical trial agreements, if I understand those can be managed by CTRMG, some clinical trial agreements come to OSR. So whoever your contract officer is that you're working with on that specific agreement, you'll want to make sure you communicate with them all of your overall goals for that study and make sure you clarify where data is going, which party it's going to. So if you have a CT that you should have a SPO related to that if there's a funded CT, and you'll want to make sure that that officer understands that they need to include those data sharing terms that to incorporate that. Same thing if it's an outgoing sub award, our office should be told where the data is going and then asked to include those terms into that agreement. Sue, do you have anything to add to that?
Nope, that sounds right. Yeah,
Okay. I think, yeah, just clear communication directly with the institutional official that's working on that agreement.
agreed.
Great. And there's a question about pre-approved vendors who have DUAs. And I think the answer to that would be each DUA with each vendor is different because the research agreements and terms are different. Is that correct? We don't
That
necessarily have pre-approved vendors.
that's correct. There's sort of a parallel where if it's a very frequent and known collaborator, it's often easier to negotiate with those parties. I'm thinking groups like UCSF and other academic institutions where we have, hundreds of agreements with them. We sort of understand what the pain points are and what the past negotiation will bring. So it's often a faster negotiation with those parties. But like you said, we don't have a pre-approved list of vendors in that sense.
Excellent. Here's a complex one. Are there any specific international considerations that need to be made for data use agreements? For example, this research team is planning a study with in an international country, and they have an MOU between Stanford and the international study site. Is an additional agreement required per Stanford's policy, meaning the data that's transferred associated to the MOU or collected as part of the study.
So I think that I think I would say it depends. It kind of depends on maybe additional information based on that situation. For example, if Stanford is one of the parties going out there and directly collecting the data, that would not necessarily be a transfer of data. Whereas if it was that the international site was collecting all the data and making it available to Stanford, it would largely depend on what the international site said about their provision of the data to Stanford, right? So going back to, are they going to require a separate DUA for transfer of that data? So it kind of depends on, I think, additional information that we'd need to glean from that specific situation.
Great. As it pertains to publications, all publications require that data be made available. Does that mean that all publications now require a DUA?
I don't think so. Sue, have you heard this? I've had this come up before. I thought that was a separate kind of task or issue of publication versus.
Yeah, I would think it depends on the journal, and some journals I think have different requirements for data that is needs to be made available. I think there are some journals that allow for, like for example, if the data is proprietary or human subjects data, the journal will allow for DUAs to be used in that instance. Um, but I would think it depends on what the data is, the nature of the data, and perhaps not even the journal's own requirements, but Stanford's institutional requirements with regard to who's accessing the data and what kind of data it is.
Got it. Thank you so much. I believe those are the basis of the questions that we have in the chat. There's some questions regarding timing, but of DUAs from start to approval, but I think that is driven by the complexity of the agreement and what the data is shared. So, putting an exact time frame really isn't appropriate, but um, maybe do you want to speak to that if I'm in the right ballpark there?
Yeah, I think that's absolutely correct. I would kind of reiterate some of the things that we touched on in this presentation, which is if there are specific timing concerns to discuss early with the institutional official, um, aka the officer, as I've referred to us throughout the presentation, about what the needs are, what the time constraints are, and having that discussion like as soon as you know that it's going to be an issue, so that the officer can help navigate what's needed and, if possible, right, if possible, sort of a big one, expedite the agreement.
Excellent. All right, we have addressed the questions in the chat. Do others have questions that are on the seminar today? Feel free to come off mute or continue to type that in the chat.
Hi, thank you so much for this session. Like Grant said, so many questions and such a great presentation and topic. I'm just like reading through the questions in the chat. It feels to me like there's still some kind of confusion about when people should reach out if they think that they may need a data use agreement. And some questions are about like, do I need to wait for my IRB to be approved? I was wondering if you could comment. Could anyone ever reach out too early to ask you questions about things that may come up, even if they don't actually have their funding in hand or have the IRB submitted, especially for some of these complex multi-site projects? Could you comment on, when would you want to hear from people about the questions that they have?
So I would say it's never too early to ask questions. It's, it might be sometimes too early to actually initiate a DUA, right? Because we can't draft an agreement if we don't know specific details about who's receiving or sending the data or what the data is. But if any faculty or department administrators have kind of like high level questions or situations that they're not sure of, I would highly encourage them to reach out to either our intake team to triage that question or even to me or Allison. I'm always happy to talk through questions that investigators have and the best way to, submit RAs and if an RA is even needed, like what makes sense in this case. Always happy to talk through those questions. And I would also say that, speaking to your earlier question, it's not, we don't always need an approved IRB to start discussing the DUA. Those can definitely happen concurrently. But I think as someone noted in the chat, we won't typically sign the DUA, but we can get through all of those sort of administrative hurdles involved with the DUA, even as the IRB review is ongoing. Allison, did you have anything?
Yeah, I wanted to add that if you're in a situation where you're hearing from an NIH program officer or a subcontractor PI that the NIH grants just in time phase, or you're hearing mumblings that your study's about to be funded and that will involve multiple sites and complex data sharing, I think that's the time to reach out to your institutional official and ask what kind of explain the situation. I'm going to get this large cooperative agreement coming in with 3 outgoing subcontracts, and we're all sharing data between all of the sites. Have that conversation early on with your institutional official so that they can help set up and direct you in the right place to get the right approvals, understand what data is being shared and with which parties, so that we can look at those outgoing sub awards and make sure we incorporate all the terms in there. Or if it's incoming, we understand if it's an incoming subcontract, we understand what data we're sending to that pass-through entity and can get you set up in the right direction. And I think I just saw something in the chat about the IRB wants a DUA approval, but the DUA approval wants the IRB approval first. I do think those things can go in parallel. And like Sue said, we can't maybe sign the DUA until we have the approvals in place, but we can certainly draft, negotiate, get it ready for signature. And when we have all the regulatory and compliance approvals, we can sign off on that. Um, I will say from the sponsored projects side with the funded agreements, a common thing that I see is that there's no e-protocol linked to the SPO number when I get an agreement. So I can't find the right IRB to look and make sure that what's listed in the agreement is aligned with what's listed in the protocol. So I'm definitely looking for that submitted IRB. You don't necessarily have to have approvals, but I'm looking for that so that I can start seeing what information you've put into the IRB protocol to help me understand what's happening in the project that's being funded.
Thank you.
Yep.
Hi, I have a question. I find often when we're working on grants, first people we work with in OSRs are RPM. And I think usually we're so focused on all the pre-award stuff at that point in the funding that when I mention the sharing of data and materials, it sometimes feels that's just not their area of focus all the time. And I think they more are looking for us to have those conversations with their like contracts and grants officer through RMG. But usually then I feel by the time those contracts get kicked to the grants contracts officer, we're so close to signing, it feels like adding on the concept of also sharing data or materials slows everyone down a lot. And is there, should we be having conversations with different people sooner, or what's the best way to go
I,
about doing that?
I think you might want to have conversations with different people sooner. I think one thing I wanted to note is our Sue and I are not part of RMG,
Yeah.
the
Hmm.
research management group. So that group is definitely the grants RPMs. They're definitely looking to help you prepare your PDRFs and your budgets and looking for those things. So you'll want to reach out to your contract and grant officer or your RRA officer in Office of Research Administration, so me or Sue, and start discussing your data sharing, material sharing plans that you have for that study so that we can point you in the right direction. I do think the grant RPMs aren't looking at that as much
Right.
in detail. They're looking to
Hmm.
see there's now a question in Sarah as part of the PDRF, the proposal development and routing form that
Hmm.
says,
Hmm.
are you sharing data? Are you sharing materials? And it's just a simple yes, no. And that's meant to get the conversation started so that we can ask more detailed questions. So I do think you'll want to reach out to folks on my team or Sue's team earlier on to ask those questions about data sharing and material sharing so that we can get that going for you. Does that help
Yes.
or
Thanks,
answer?
Allison.
Okay. Yeah, sure.
Well, we are at time. Um, was a tremendous session. So thankful for you, Allison and Sue, just taking the time out of your day, all the planning you put into this. We're so grateful for everyone that attended. The session, as I mentioned, will be recorded and posted on our website. And we hope you all have a great rest of your day. Thanks so much.
Thank you.
Thanks, everyone.